Welcome back to Adalat. I have two very competent solicitors in the studio with me today who are giving us a lot of information about the areas they practice in. Before we go to Gurpreet to talk a little bit about immigration, I think I want to get back to Anthony and complete the discussion that we were having. You were talking about the general area of civil litigation.
Yes, I was actually we were discussing about the areas that I specialize in. So debt recovery work where individuals are owed or corporates are owed money. Landlord and tenant work whereby the landlord wants to evict a tenant. We can assist with that. I also deal with the other flip of this coin whereby the tenant is resisting a possession claim based on substantial grounds. So perhaps things like disrepair or lack of protection of deposit. And also matters pertaining to contractual disputes. So perhaps if you have a contract which a party has breached and you want to bring a claim for damages, those are the sort of work we can assist with.
Right, so that's quite broad.
It's quite broad.
I mean, contracts, what kind of people would enter into?
My clients range from the local jeweler down in Kingsbury High Street who had given out jewelry to a firm in Leicester, because within the community, I have actually acted for clients who had been in the, they run jewelry shops, and I think traditionally they give jewelries on trust without having a formal contract.
So word of mouth used to mean something once.
It still does. And
does it?
It still does, because surprisingly, I still wonder how someone could give jewelries.
Which is so expensive.
£100,000.
Yeah.
It still goes on in the community, and I have experienced this, but it is still what it is, word of mouth, trust.
Yes.
Especially the first generation of the community that came to the UK, trust is very crucial.
Of course.
And they haven't actually evolved to having this formal agreements
and contracts
and I think in a way, it should be formalized, but those are the sort of things I can help with. So when there's a dispute about the terms of the oral contract, because in this particular occasion it was to do with the oral contract, what was agreed, what wasn't agreed, and because there wasn't any documentary evidence, it was a bit difficult deciphering and getting through to the bottom of it, but we were successful and we managed to obtain substantial
award. But tell me, how does an oral contract get proven in court, for example? How do you prove it?
I think what it is, it's also to do with the facts, the key issues, the witnesses, people who were present. Obviously, this had to go to trial, and after cross-examination, the judge believed that version of events as opposed to the other side's version of events. Right. I think it's all to do with the key. In the particular case I dealt with, it was really to do with the witnesses who gave clear evidence about what had happened.
Right.
And the judge did believe but the advice I'll give to the viewers is try as much as possible to put things in writing, because it saves a lot of trouble. If everything is put down in writing.
We've reached that stage where oral contracts and oral agreements just don't stand up in today's. I mean, we were talking about we have to change with the changing times.
Precisely.
And at one time, what people used to see as good, for example, you're saying that somebody would give jewelry worth 100,000 to another jeweler on trust. At one time that was considered to be something good, and that person would be seen as someone very respectable. But in today's day and age, people like that are seen as stupid.
Yes.
Now if someone's good and honest and ethical, people think, oh, this person's stupid, we can just take advantage of them.
That's true.
Times have changed a lot.
He has definitely changed.
Very sadly, time has changed, not for the better, I don't think. So this is all very useful information. Now, coming to Gurpreet, usually he would have talked a lot more than this by this time on the show.
Quite a lot of vital information Anthony has given today.
It's good. You see, the thing is, there was a time when this was the only show that people watched to do with immigration. And so we used to take all the immigration calls and we used to give out all the immigration. But now, even on our channel, there's a daily immigration show. So people can phone in. I've always tried to go into new areas and try and give the community information about new areas of law, which also affect them almost as much as the immigration issues affect them. But of course, we do understand that immigration is a live issue, it is ongoing. So Gurpreet, what are the latest developments in immigration? If you could just give a little synopsis for our viewers, please.
Well, there are quite a lot of changes now in the immigration. The new areas, and especially the students there are now the students, there are different where the students have to meet the requirements as English language requirement. If you are NQF level 7 and above, only then you can bring your family members, and you are permitted to work 20 hours per week. But if your level of qualification is NQF 3 to 5, then you are reduced to 10 hours per week. So in terms of student categories, there are quite a lot of changes coming. Then as far as the other bit, asylum bit is concerned, there is a lot of litigation recently going as far as the detained asylum casework process is concerned. Earlier there was a fast track, which was called as detained fast track process, where the people who used to claim asylum, they were detained and their cases were tried under the detained fast track process. That wasn't the challenge in the High Court in judicial review. And then there were orders that there were certain vulnerable clients which were not actually identified by the Secretary of State, and they were still pursued under the detained fast track process. So then the Minister of State came up with suspending the detained fast track process.
Is it still suspended?
It's suspended, but now it's like detained asylum casework process, where the people who are detained and when they claim asylum, then the Secretary of State actually consider their cases while they are detained, and they pursue with the cases in detention. Now there are certain individuals who claim that they are victim of torture, and or they have suffered some sort of ill treatment, or they have got some kind of a special illness. Now when they are in such a situation, then they can always approach the healthcare in detention to ask for which we call as a Rule 35 of the detention rules. They can ask for the examination, where doctor conducts the examination, and if the doctor feels that these individuals are could be potential victim of torture, then that report is referred to the Home Office, where the Home Office has to make a decision whether it is appropriate or suitable to detain this person or to consider his asylum case while in detention. So there's quite a lot of litigation which is now currently ongoing, or continuously people are challenging their detention, that they shouldn't be detained because they are a victim of torture, and they should be released, and then they should be their asylum case should be considered in the non-detained asylum process. So this is a growing area of litigation, as I was discussing earlier, that where people also challenge not only that their cases, asylum cases, should be considered under the non-detained process, but also the Secretary of State was not right in continuing their detention, and therefore their detention was unlawful. And in order to challenge that lawfulness of detention, they approach the High Court. And if the High Court declares that yes, these individuals, when they were seen by a doctor in detention center, and the doctor actually gave Rule 35 report saying that this person was a potential victim of torture, or there is any other independent evidence which shows that they were a potential victim of torture, then they shouldn't have been detained. So there are cases where people are challenging the lawfulness of detention. If the court decides that yes, detention was unlawful, then those individuals can always apply for damages to the Secretary of State. So there are quite a lot of changes in these terms.
What really amazes me is that I also practice law, as you know. In order to be convicted of a common crime like shoplifting in England, people are put through a proper legal process, their cases are heard, and due process takes place. Only after that they are detained, and many of them are not even detained, they have suspended sentences and so on. But in immigration offences, people have not really committed a crime, and yet they are detained, and they are put inside and kept inside long before any due process actually takes place. And this anomaly actually really concerns me as a lawyer, that people who have not committed any crimes can just be put away in detention and then their cases are not heard for ages and ages. And I've actually dealt with bail cases where people have been in detention for years, not months, but years. And many of them don't bring any action against unlawful detention and so on because, and I look at a lot of them and I feel that a lot of them would be entitled to this, but the problem is, first of all, they're not focused. As clients, they're not focused, they're not in the best mental state to actually take any action like that. Secondly, a lot of the solicitors who practice in that area are not necessarily client-focused and thinking of the client's welfare. And sadly, a lot of people who practice in this area are really not bringing about as many cases as should be coming forward in unlawful detention and other types of unlawful behavior that goes on, particularly with immigrants. But the problem is with immigrants, their main concern usually is to somehow legalize their stay. And they don't think of going that one step further. I don't know what you both feel about that.
I mean, I would like to just, it's a very, very important point which you have touched, which I think the viewers should know about it, and that is that there is a distinction between asking for a release in bail or challenging the lawfulness of detention. So most of the time the individuals or the applicants, they continue lodging the bail application before the immigration judge, which gets refused. And as I was saying, that if the applicant claims to be a victim of torture and he is claiming that he should not be detained because of being a torture victim, then he's challenging the lawfulness of detention. Whereas this issue, bail judge doesn't have a jurisdiction or powers to decide whether individual is lawfully detained or not. So bail judge will only decide whether there is a risk of absconding, whether this person should be released, and if he's going to be released, whether there is a risk of absconding, whether he's not going to comply with the bail conditions or not. So that's where the applicant needs legal advice, that if the risk of absconding is a different thing, and lawfulness of detention is a different thing, lawfulness of detention can only be challenged in the High Court, where the applicant can bring all these issues before the judge.
And how does one initiate such a procedure? Anthony, could you help us on that?
I think, just going back to what you said earlier on about the solicitors or the legal representative, I think I agree with you that some of them, excluding my colleague, Gupit, of course, the rest of my colleagues.
Those guys don't appear on my show. Can I just tell you, I'm very particular.
I think some of them are actually unaware of how to bring about this. And I think one of the issues that they may not be aware of is how to fund this sort of litigation for unlawful detention, and simply focus purely on doing what in their comfort zone they know best. Yes,
comfort zone is the thing.
Precisely.
They don't want to, go beyond the limits that they know.
But then, isn't it the case that solicitors should also refer those sort of clients who they think will need that assistance, or in fact legal representatives, to other lawyers who will be able to assist them, because there is really a case for this sort of matter to be taken up to the High Court to challenge the unlawfulness of.
And I think currently there are a lot of people who are detained who are probably entitled to compensation and who are probably wrongfully detained for the period of time, because we all know that imminent removal is not really imminent.
Yes.
Because, it just goes on and on, doesn't it? The process of removing people, it's not that easy. Are we going to a break now? We're going to another break. We'll meet shortly. Keep watching Adalat only on Venus TV.